Greetings and citations, my fellow sovereigns. This is the Saturday night Civics and 70 class for the Vocational Science of Freedom. And tonight we'll be continuing our reading of a treatise on a practical treatise upon the law of judicial writs and process in civil and criminal cases, the sufficiency, validity, amendment, and alteration of process, its execution and return, and the powers of liabilities of officers thereunder. This is a 1895 treatise, and it's right around that time where they were changing up the difference between their processes from common law to code pleading and pushing in Roman civil law. Now, we've gotten through parts 1, the Roman and English, and conclusion, chapters 2 and part 2, and we've gotten part 2 all the way down to chapter 4, to irregular and erroneous process. And I believe that left us off at page 96, as I recall. Okay, so section 15, irregular and erroneous process. And I know since I'm going to be jumping right into this, you're going to want to go and listen to episode 1 and episode 2 if you just happen to be listening to this online and just jumped right into the middle of this class. We covered a lot of the vocabulary words in the first 2 classes, so I highly suggest you would go back and watch that first, or else you might be a little bit lost. Okay, section 15, irregular and erroneous process. The imperfection of judicial diction extends to an attempt to establish a difference between the meaning of the terms irregular and erroneous, rendering the former synonymous with the phrase void process, and the latter being used to denote process that is voidable. And that's something that we talked about in class 2, what is automatically void and what is simply voidable. The words irregular and erroneous only mean a derivation from an established course or form, and when applied to process merely indicate a defect without specific its seriousness or what its effect may be. Both words are properly applied to all process not issued in strict conformity with the law, whether the defect there or irregularity appears to be on the face of the process or by reference to extringent facts, and whether such defect renders the process void or only voidable. And just to give some examples of this, just for a little kind of reminder, so what would be something that would be absolutely void? Okay, you have, say, a warrant. Warrant is process, as we learned in previous classes, reading this treatise. So you have a warrant. If the warrant is not signed by a magistrate or a judge, is it valid? The answer is no. That makes it void, not just voidable. Something that could be voidable would be, say, something on the warrant. Say they have say they have the address correct, but say they might have misspelled the name of the road per se, and say there was only one road that ever came close to that sort of spelling. That would be irregular and that would be voidable, but it wouldn't necessarily be void on its face if everything else was absolutely correct. And we'll get into some of these other things that are void and voidable as we continue here, but I just wanted to give a little bit of an example of what that means. Okay, so chapter 5, style or title of process. So now we're dealing with what's the style of it? What's the title of it? Is it titled correctly? And I want to preface this whole entire chapter with a important aspect of law, and that is that titles technically do not control. So what I mean by that, if you say write a lawsuit and you say mess up the title a little bit, but everything in the body of the lawsuit itself is correct, well, then it doesn't void or negate the validity of the lawsuit just because the style or the title might be slightly messed up. So, and now we'll see exactly what this says regarding the common law. So, definition of style or title. In discussing the form and validity of process, the subject first in order is the style or title of writs, which are formal words preceding the body of process and signifying the authority of government as the quote-unquote state of Missouri, the quote-unquote Commonwealth of Kentucky, in the people of the name of the state of Michigan, in the people of the state of Illinois, and so on and so forth. A writ is properly said to run in the name of the persons or government from which from whom or which the command on the face of the writ appears to emanate. Okay. I'd like to clarify that a little bit because the attorney wasn't exactly very specific there. A writ is properly said to run, I would say, in the name of the sovereign. Period. Full stop. And that's what it says up above. In the name of the people of the state of Michigan. Are the people the sovereignty of the state of Michigan? The answer is yes. Is the state of Michigan sovereign? The answer is no. Right? So, as the one that says just state of Missouri, I'd be pretty sure that the Constitution for the state of Missouri does not say that process shall run simply in quote unquote state of Missouri. Can pretty much guarantee that. But, so to continue, the styling or entering of process is not only of long and customary usage, but is required uniformly by the constitutions and statutes of the several states, a violation of which has been cause for much judicial controversy. As I said, this stuff is going to come directly from the constitutions. I'm going to skip down to section 18 here. Omission to style or entitle process continued. Other courts have declared that the constitutional and statutory provisions concerning the styling of process must be obeyed. Otherwise, the writ is void. Now, I personally would agree with that, particularly if you have a constitutional mandate that process shall run in a particular name, obviously the name of the sovereign of the state, and it does not do so. I would absolutely consider that to be void because it's not coming from the sovereign. It'd be coming from what? Oh, I don't know, maybe a corporation pretending to be a de jure government that was created after, oh, I don't know, Reconstruction. You know, get the point. So, it is so declared in Kentucky, Michigan, West Virginia, Nevada, and Tennessee, and, as stated in the preceding section, Illinois, has twice announced the same opinion. The premises given which result in such conclusions are these. Quote, judicial process is but the command of the sovereign, which is exactly what I just said. Commanding the person or officer to whom it is directed to do certain acts therein specified, and it is therefore appropriate that such process shall run in the name of, again, it should say the sovereign, not of the government. But whether appropriate or necessary or not, the Constitution requires it, and what that instrument requires should be done without hesitation or inquiry into the question whether, abstractly considered, the thing required is essential or not. Close quote. Period. Now, why is that so important? Because without hesitation or inquiry into the question whether abstractly considered the thing required is essential or not, it is essential. If the people have decreed, ordained, and established the Constitution, and that's what the law says, that is the foundation of all law in that state. You have to follow it. Don't care if you don't like it or not. I don't care if you get up on a Monday morning and you're lazy and you're a clerk and you don't want to write it all out. Tough shit. Do it. It's constitutional. If you don't like it, stop being a public trustee then. Go find another job. Because as far as you're in that position, you shall obey the law of the people. That's the whole point. To continue. Quote, the object is to make this style the distinguishing feature of all process. The requirement is constitutional and the defect jurisdictional. Meaning that, this is my little note, meaning that if you look at what they have filed onto the court record and what they filed does not follow the requirements of the Constitution for the state, then that process, whatever it is void. And that would include even them messing up the construction of a statute. Now, let me give you an example here. Say they constructed a statute regarding criminal due process. Let's just say that. And say they write some statute and it does not follow the Constitution. Okay. If just because they were following the statute when they were doing it, because the legislature messed up because they didn't bother to go read the Constitution correctly, is that process valid even though they technically followed the statute? And the answer would be no. And there's been cases regarding that gone to the Supreme Court of States, and the Supreme Court of States pretty much said, no, you pretty much have to follow the Constitution. It's too bad that the legislature decided to mess up, but that does not, under any circumstances, waive the validity of what needed to be in there. So All right, to continue. Quote, a particular form when prescribed by the Constitution becomes matter of substance and must be pursued. That was my point. Skip down to section 20 here. Section 20, defects in style or title. Though the Constitution requires all process to be styled, quote, in the name of the people of the state of Illinois, close quote, yet the form, the people of the state of Illinois, is sufficient, and the omission of the is immaterial. In a Missouri case, a writ was styled and directed State of Missouri, County of Sheraton, to the constable, etc. This was declared insufficient in form, and that it should have been the State of Missouri, to the constable, etc. Where the Constitution required process to run in the name of, quote, the state of West Virginia, a writ was held to be fatally defective when it was styled the Commonwealth of West Virginia. A decision which indicates a decision which indicates a religious regard for form in keeping with the narrow views of ancient times. I'll let all of you chew on that one yourself. Now I'm going to skip down here quite a bit because this next whole section, direction or address of process, I don't want to get into because it's about again kind of like the thing that I said about having the address being correct or wrong, and I don't get into all that. It's basically holds the same as the rest of these things are required. Okay. However, there's one little section here: direction of miscellaneous writs regarding writ of certiorari to the Board of Police and not to the commissioners individually. A writ of error must be directed to the court where the record is. A writ of mandamus must be directed to all whose duty it will be to obey its commands, should it ultimately issue. It is properly directed to a railroad company in its corporate name, although the performance of the commands must be through its officers. The writ should be directed to a county in its corporate name. Catch that. To a county in its corporate name. Yes, the counties are corporations. A mandatory writ is properly addressed to the mayor and the aldermen of a city. And as it is elementary that a writ must be directed to those whom it commands, there has been but little controversy as to this matter. Prerogative writs should be addressed to all whose action is necessary to complete the duty sought to have performed, and by their proper name and description of office. Now, this would also have to do with, and since they don't elaborate on it, I'll take the liberty of doing so. Okay, any prerogative writ. That would be mandamus, quo warranto, habeas corpus. So prerogative writ. Whose prerogative? The sovereign's. So if a sovereign says, you know what, we don't know what you guys are doing over there in the state, but, and I'm taking the Viper's current situation as an example. It would appear as though we can't find, 42 of your oaths that have never been filed, and none of you have a bond. So what is it exactly you think you're doing? Right. So when the sovereign or a group of sovereigns says, we're going to do this by a prerogative writ, it should be addressed to all whose action is necessary to complete the duty. So every single judge that he's found, and it's not just judges, it's also district attorney, and I think it's technically even the attorney general, and some minions thereunder, also don't have their proper oath and bond, that all of them need to be named. Okay, so that's kind of what this is getting at. They all need to be named, do them all at once, put them all into the bus at the same time. You do not need to file a separate writ for each individual trustee. Okay, just a little clarification there. All right, chapter 4. The Teste of process. Teste. Formal features of Teste, immaterial defects in Teste, material defects in Teste, the author's views, same subject. Section 27. Forms and features of Teste. The Teste of process is the witnessing or concluding sentence of the instrument. In its usual form is witness H.H. Nolan, comma, clerk of the said circuit court, with the seal thereof hereunto affixed, at office in Independence, comma, this 3rd day of October, comma, 1894. Now, a little bit of history of this that's kind of funny, honestly, but it's relevant because it's where we get the word from. Okay, Teste. Sounds like testy, doesn't it? There's a reason for that. When in the ancient world, men were called to testify, they were required to do something that was rather interesting. They had to hold on to their testes. And if they were caught lying, what they were holding is what they lost. No, that's not a joke. Yes, it's true. And yes, this is why this word sounds like teste, because it is. And in the ancient world, women were not allowed to be witness to anything because they didn't have any. So that's where it comes from. That's the etymology of it way back in the day. Now, what I'd like to show everybody as far as an example is I'm going to bring up the Teste that we use in the VSOF status doc set. And I'm just going to make sure that you guys can see this. Okay. Yep, you should. So this is how we end all of the documents in the Vocational Science of Freedom status doc set. Doesn't matter what it is. They're all of them that, okay, let me put it this way. All of them that require a teste. This is how we have it. So witness now, comma, James Henry, House of Doe, comma, one of the people of Michigan, comma. Now, if there's a requirement for an office, this is where it goes. So it would be if it was, say, paterfamilias of the House of Doe, right? Or materfamilias of the House of Doe, comma, holder of the seal of the House of Doe, comma, with said seal thereof hereunto affixed, comma, attested by his own hand, comma, who stands upon the land of Michigan Republic. Now, where did I get this from? I got it from this treatise. Right here. That's where I got it from. Now, I had to alter it, obviously, a little bit from the standpoint that we're acting in our own sovereign capacity, and we're not acting as a clerk. But you could do it from a standpoint of the teste of, say, you were acting as a special master for someone's superior court. Where would you put it? You'd say special master of the superior court, right? Would you still be one of the people? Yes. Would you still be the holder of the seal of the house? Yes. Would the seal still be affixed? Yep. Would it be attested by you? Yep. Would you still be standing upon the land of Michigan Republic? Yep. So the only thing you'd add would just be the office then, right? So just want to show you guys that. All right, next. Its salient and necessary features are in the name of the officer, the description of the office, reference to the signature and seal, statement of place, and the date of the attestation. Number 28, immaterial defects in teste. The defects in process, which have given cause for much contention and often resulted in serious consequences, extend also to the teste. Process from which the teste has been entirely omitted has been declared amendable and valid. And this notwithstanding the statutes of the state requiring process issuing from a court of record to be testated. All right. Section 29, cases contra. The opposition of opinions upon the significance of the teste of process and of the consequences of defects therein further evidences the importance of the subject of this treatise. Again, the cases cited in the preceding section there is respectable authority. It is pertinent and of interest to quote at length from one in which it was held that failure to mention in the teste of a writ the affixing of the seal was a defect for which the writ could be quashed. Quashed meaning gotten rid of. Quote, there is perhaps no form of judicial proceeding, said the court, that can be traced to greater antiquity than that of referring to the seal in the attestation of sealed instruments. Kind of getting at what I was talking about a moment ago. We are not tenacious to the form merely because it bears a vestige of older times, nor merely because it is generally recognized by courts of record, but we adhere to it especially because it contains marks of propriety and utility. It is true that the seal proves itself, but it does not itself prove that it was affixed by the proper officer or by authority. Maybe somebody stole the seal, right? The clerk is the keeper of the seal, as you are the keeper of the seal of your own house. He alone, or she alone, is authorized to use it, as you are the only one authorized to use your house seal. And upon affixing the seal officially to any process, he should attest to the fact over his own signature. There is a propriety in this form of attestation because in uniformity prevails and is looked for in every genuine writ. And there is utility in it because it is one of the safeguards against surreptitious authentication. Ministerial officers of courts are too much inclined to depart from established forms and fixed rules. Innovation is not within the providence of their duties, nor can they be justified by us in any derivation from forms well known and regulated, long defined. And regulations long defined. Like I said, all of this all comes from the ancient world and the common law, if you will, the customs and usages of seals and sealing instruments properly and by certain officers. However, the court also said, quote, the defect in the writ may be regarded as technical, merely formal, as one which might have been conditionally amended on motion in the court below, but still it is a defect, an omission of the established form of a writ which should not be overlooked. The omission of the name of the clerk from Teste was held to be a fatal defect. In an early case in North Carolina, the writ being attacked by what? By plea and abatement, which again we covered in the previous class about how you can use a plea and abatement when it should be used. The Constitution required process to, quote unquote, to bear Teste and be signed by the clerk of the respective courts, close quote, a provision common to the constitutions and statutes of the several states. Let's skip down to 31. And now we have chapter 8, sealing of process. This is a little note that I have on here as far as my personal is concerned. I have long been asked by many students of the VSOF where I can find information on the importance of the use of my house seal. The following section I give as reference to all matters regarding the history and use of your house seal and the importance thereof in all of your court process that issues from your court of record. So if anybody in future times wishes to learn more about the seal, I will absolutely point them towards this particular recording. Section 31, importance of sealing process. Of all defects that have invited objections to process, none has been of more seriousness than the omission of the seal, and the subject of this chapter is of special interest and importance. The execution and attempted service of unsealed writs have been productive of litigation that has unsettled and endangered personal and property rights. And such is the conflict in the adjudication upon the subject that they confuse rather than enlighten and instruct. The most prominent of American jurists have not agreed as to the effect of unsealed process. Mr. Justice Miller and Judge Cluley have announced opposing views, the former declaring such process void, the latter asserting it to be voidable only. Judicial proceedings long acquiesced in have been successfully attacked because of the omission of the seal from some writ. If you guys don't know what that means, judicial proceedings long acquiesced in, meaning when no one said anything for years and years and years and years and years, and then somebody realized, oh, wait, shit, they didn't ever put the seal on it. They have been successfully attacked, meaning they got sued out of existence because of the omission of the seal from some writ. Sales have been declared void. Parties in the peaceful possession of land have suddenly been ejected and caused to realize the speculative and uncertain features of the law. While murder itself has been reduced to the minor offense of manslaughter. As long as clerks of courts who keep and affix seals to process are liable to error, unsealed writs will issue, and the effect of such omission deserves extended and careful consideration. We desire to introduce the subject by an epitome of the history of seals. History of the seal. A historical consideration of the seal will disclose that it is of extremely ancient origin, that its use was impelled by illiterateness, it being a substitute for signatures, that its purpose was authentication, and that originally it was of more importance than the signature. The ancient Hebrews wore their seals or signets in rings on their fingers or in bracelets on their arms, and could execute written instruments with the convenience of present time, when pencils or fountain pens we have always with us. And I would go to add that the Greeks also did this, as did the Egyptians. Scriptural passages concerning the use of the seal tell us that it was a substitute for the signature and a means of authentication. The use of seals, says Sir William Blackstone, should have read or should at some point read Blackstone's Commentaries, probably the single best volume of books to read upon the common law. Blackstone says, quote, as a mark of authenticity to letters and other instruments in writing is extremely ancient. We read of it among the Jews and Persians in the earliest and most sacred records of history. And in the book of Jeremiah, there is a very remarkable instance not only of an attestation by seal, but also of the other usual formalities attending a Jewish purchase. In the civil law, also seals were the evidence of truth and were required on the part of the witness, at least, at the attestation of every testament. And just as a note here, every time you see the word civil law, it means Roman civil law. So to continue, but in the times of our Saxon ancestors, they were not much in use in England. For though Sir Edward Coke relies on an instance of King Edwin's making use of a seal about 100 years before the conquest being in 1066, just for historical references, yet it does not follow that this was the usage among the whole nation. And perhaps the charter he mentions may be of doubtful authority from this very circumstance of being sealed, since we are assured by all other ancient historians that sealing was not then in common use. The method of the Saxons was for such as could write to subscribe their names, and whether they could write or not, to affix the sign of the cross, which custom and illiterate vulgar do for the part of to this day keep up, the signing a cross for their mark when unable to write their names. And you saw that a lot with illiterate people all the way through, well, from the time they're saying pretty much up until the Revolution, because there weren't a lot of people that were illiterate at the Revolution, slaves obviously being, aside from them, of which, of course, they had them sign with making their mark or making their X, which turned into an X, which used to be a cross, but then got tilted for what reasons, I know not why. Okay, to continue. And indeed, this inability to write and therefore making a cross in its stead is honestly avowed by Cadwalla, a Saxon king, at the end of one of his charters. In like manner, for the same unsurmountable reason, the Normans, a brave but illiterate nation, at the first settlement in France, used the practice of sealing only without writing their names, which custom continued when learning made its way among them, though the reason for doing it had ceased, and hence the charter of Edward the Confessor to Westminster Abbey himself being brought up in Normandy was witnessed only by his seal, and is generally thought to be the oldest sealed charter of any authenticity in England. At the conquest, the Norman lords brought over into this kingdom their own fashions and introduced wax seals instead of the English method of writing their names and signing with the sign of the cross. And in the reign of Edward I, every free man and every such of the more substantial villains as were fit to be put upon juries had their distinct particular seals. And I made a note here. It said Edward I, also known as Edward the Longshanks and the Hammer of the Scots, was King of England from 1272 to 1307. The impression of these seals was sometimes a knight on horseback, sometimes other devices, but coats of arms were not introduced into seals, nor indeed into any other use till about the reign of Richard I, who brought them from that should be crusade, in the Holy Land, where they were first invented and painted on the shields of the knights to distinguish the variety of persons of every Christian nation who restored thither, and who could not, when clad in complete steel, be otherwise known or ascertained. This neglect of signing and resting only upon the authenticity of seals remained very long among us, for it was held that in all our books that sealing alone was sufficient to authenticate a deed. A deed is just something done. And so the common form of attesting deeds sealed and delivered continues to this day. That should really be signed, sealed, and delivered, which is where we get this term from. Notwithstanding the statute of 29, that's not sure. I don't know who that is. CAR. I don't know who that's an abbreviation for. Second, before mentioned, revives this action custom and expressly directs the signing of all grants of lands and many other species of deeds in which therein signing seems to be now a necessity as sealing, though it hath been sometimes held that one includes the other. It has been correctly said that it, quote, it is the condition of an ancient society that we must search for the importance attached to the seal. In early times, with respect to all instruments, whether private or public, the seal was the chief and essential proof of the authenticity of the document. It was guarded with jealous care, to prevent its unauthorized use. One instance is recorded of a seal separable into 4 parts, the parts being assigned to separate keepers as additional security against its fraudulent employment. In that day, the seal upon its face identified its owners. Writing was not common as now, and there was necessity to authenticate the execution of documents by some solemn act, speaking the consent of the party. The seal met that necessity. As to private writings, a substitute for the signature. I would also add, because I don't recall if they go over this in this treatise or not, I would also add that the sealing of a contract raises the severity of that contract to an entirely different creature altogether. It changes it from just a contract to being a covenant. And if you have a contract under seal and someone breaks that contract under seal, you can then sue at common law for an action of covenant. And if it's not sealed, you don't have that. So just wanted to add that in as a historical understanding that you can have and do have a covenant once you have a document signed and sealed. So to continue, the earliest mode of commerce was by the exchange of a cow, sheep, or goat for some other commodity. And, quote, it is supposed that the image of these and other animals stamped on leather or other yielding substance by wood or metal constitute the first currency as well as the first use of seals. Next, the impression was made on the metals, certainly superscriptions indicating the value of the coin. Next, contracts were attested by seals, either where calligraphy was not known or where the party could not write his name. Lord Coke defines a seal to be a wax with an impression. I'm not going to bother reading that Latin for you. This was the common law definition of a seal. It is a matter of surprise that up to the time of Lord Coke, there was neither an adjudication nor an act of Parliament prescribing the essentials of a seal. And just Lord Coke was an English lawyer and judge, and he lived from 1552 to 1634. If you find any of his writings, I highly suggest reading them, even though some of them might be a little bit difficult to read because you might have a little bit of Old English in there. Not that that would hurt you. But when writs came into use, it was most natural that one of their features should be the reverenced seal. This was incident to the conditions of society and the necessities of the government. An original writ issued out of chancery and in the name of the king, the fountain of all justice. And kings have had their seals since the time of Jezebel wrote letters for her husband, Ahab, king of Samaria, to the elders and nobles, quote unquote, and sealed them with his seal. And he was the king of Israel, in case anybody doesn't know what that is. He's king of Israel from 874 BC to 853 BC. So you're seeing this is going very, very far into the ancient world. Okay. It was a grant of jurisdiction from the sovereign to the court to which it was returnable. This now going back to the original writs from the King's Bench in England. And it was called by Lord Coke the heartstring of the common law. The seal to the writ was the symbol of sovereign power. Now, I want to pause and make a point here. The sealing of your documents from your house as you doing so in your sovereign power is the same thing. Everybody needs to use their seal. Well, first you need to get your seal, which we'll go over tonight. I'll take a look at the handbill for the Vocational Science of Freedom status docs for the house seal. There's a few things in there that I also want to cover. But the point is the first thing that a sovereign does is make their seal. You establish your house, you make your seal. This is now what you're sealing things with. And anything that you've not ever sealed anything with, you put a shadow of a doubt on it in that document, in the establishment of your house seal, which is one of the Vocational Science Freedom status docs. You say, if my signature ends up someplace and it does not have this seal with it, I cannot attest to the veracity or the validity of said signature. So basically, you're putting a shadow of a doubt on anything that's ever been thrown out there in the public realm that does not have your seal to it. Okay. Because it's important to keep this. It's important to keep your seal. It's important to use it. You'd be very surprised when banks get things that are sealed letters, or corporations get letters that are sealed. They tend to pay a lot more attention to it. Trust me. And it tends to get sent directly to somebody very quickly who would know exactly what to do with it. So in other words, you pretty much get moved to the front of the line every single time when you sign and seal something properly. Particularly also with a proper teste on it. Okay. All right, to continue. Quote, without the seal, the writ was void, conferring no rights to the exercise of judicial authority because the commission lacked the expression of royal sanction manifested by the Great Seal of State. Judicial writs, which were founded on original writs, were under the seal of the court out of which they issued, thus authenticating the exercise of delegated authority. This is exactly the same thing that you're going to be doing with your court of record. When you file a suit in a court of record, you're going to be signing and sealing your documents. When you do final judgment, you're going to be signing and sealing the final document. Writ of error, same thing. Signed and sealed. It's important. The seals of courts were entrusted to the care of custodians appointed by the king, and the sealing of writs had to be purchased. This word now being sometimes used in some of the statutes as synonymous with issued. This was a profitable source of revenue to the crown, which, with the reverence paid to the manifestation of kingly power, properly accounts for the inexorable demand that all writs should be sealed. Now, just to make another side note historically here, this whole idea of this thing about purchased with the seal, this was a profitable source of revenue to the crown. Kind of like, I don't know, the Stamp Act? In case anybody remembers that one. Big problem. The king decided to put his essence on every single piece of paper and on every single book in your house. And if every single piece of paper and every single book in your house didn't have the king's presence upon it, you could get fined. How convenient and how nice was that one? Anyway, I digress. To continue. Thus, has come the rule of the present time that process shall bear the seal of the court out of which it issues. A principle of the common law declared and emphasized in the constitutions and statutes of the different states. Exactly. Now, we're going to take a look at the handbill for the Vocational Science of Freedom. This is the first handbill in the list on the mega folder for all of the various different handbills that we have for the Vocational Science of Freedom doc set. And the first one is Declaration, Establishment, and Publication of House Seal. That is the first status doc that we do. They're done in order for a very specific reason. So, this declaration, establishment, and publication of House Seal, status document, is a declaration at law, a lawful juristic act, much like the Declaration of Independence. Filing the declaration, establishment, and publication of House Seal with your county recorder establishes it as public record and creates public notice of said declaration of House Seal. The steps to properly executing this status document are as follows. The Declaration of House Seal is the first status document that you will file onto the public record after getting your house seal made at an office supply store of your choice. They will call it a quote-unquote corporate seal in their product list or catalog. However, this seal is for your house, not for a corporation or business. The VSOF recommends getting a 1.5 inch, I would also say, or 2 inch if you want to make it a little bit bigger. And depending on how much detail you have in your house seal, if you have a tremendous amount of detail in your house seal, which by the way, I don't suggest you do, but if you want to get elaborate, that's entirely up to you. You're sovereign. You can do what you want. I highly suggest getting a 2 inch, not a 1.5, or else the minutia would be lost in the tininess of the seal itself. Okay. So embossing seal that raises or embosses the paper when you crimp it down. Imprinting your house seal into your documents. That way you cannot get rid of it. It's always there. And if you use one of the little gold stickers and then seal over the top of it, it makes a very, very nice copy and scan. The light reflects beautifully off of that gold little leaf, and you can see the seal perfectly. And there's no mistake that that's what it is. Okay. Some VSOF members also get an ink stamp for their house seal as well. The best kind of embosser to order is one that can be rotated to come into any side of the paper. However, if the company does not have that option, always order one that is oriented to come in from the right hand of the document. Then you can bring it up and down. And also the declaration of establishment, publication of house seal, you have to put your house seal basically in the middle of the first page, which is about here. So just be aware of that, guys. All right. The second part of it, we all need to create, establish, and publish our own house seal for our own houses. The house is the first political subdivision in our republic, stemming from ancient Greece, Babylon, Rome, and Egypt. You must establish your own house by creating your own charter. See definition of charter below. The declaration of house seal is the first step in creating your charter for your house. Our right to do this is protected by the 9th and 10th Amendments in the federal constitution. The said right is also protected in all state constitutions. If we, the people, establish the two houses of Congress for the federal government, House of Representatives and the Senate, but then do not bother to establish our own house, this is an error in our understanding of law and the history thereof. It is important to remember that in the 1818 Illinois Constitution, in the final part of that Constitution, there is something called a schedule. In the schedule, paragraph 6 reads, quote, "The governor of this state shall make use of his private seal until a state seal shall be provided," close quote. Proving that, at that time, 1818, everyone was expected to have their own private house seal. Because by that very statement in that Constitution, there was no way to know who was going to be elected as the first governor of Illinois. But it was clear that whoever it was going to be, they would have their own private house seal. So it's a charter. A charter, an instrument emanating from what? The sovereign power. Is that you? You betcha. In the nature of a grant, either in the whole nation or to a class or portion of the people, or to a colony or dependency, and assuring to them certain rights, liberties, or powers. Such was the Great Charter or Magna Carta, and such were also charters granted to certain of the English colonies in America. An act of the legislative department of government creating a corporation is called the charter of the corporation. In Old English law, the term denoted a deed or other written instrument under seal, which is exactly what you're doing. A deed or other written instrument under seal. That is a charter, folks. Okay. A conveyance, covenant, or contract. In Old Scots law, a disposition made by a superior to his vassal for something to be performed or paid by him. Are we doing things and we're demanding things from our vassals? Basically, those that are decided to be trustees of us, right? Can you demand that they use things? Yes, as long as it's according to law. To continue, a writing which contains a grant or transmission of feudal right to the vassal, so on and so forth. So, okay. So that'd be their own house seal. And then the duration of the house seal, the declaration of house seal acts as a lawful notice to all the world that we have had fraud regarding our estates. So all of this stuff that they're doing, from the registration of the births and all of it, all the presumptions that I want to get into, this is the first place where we cut them off at and say, okay, we're getting rid of all these presumptions from the standpoint that I've never willfully been party to any of this, because I just came of full age. I just established my house and I just created my seal and I just came forward as the heir and the executor of my estate. So everything else that I did previously, and this is also according to you, meaning the attorney, you figured that I was acting as an infant. Okay, granted, wonderful, don't care. But everything from this time forward is going to be under seal and it's going to be declared by a sovereign, okay? So the Declaration of House Seal reaffirms the fact that you are to be addressed by your proper name, and that you are of your own house, and that 4 other people who have come of full age agree and affirm under penalty of perjury to the same. The Declaration of House Seal gives anyone the opportunity to dispute anything contained in it within 30 days, and if no one who gets duly served with this document disputes it within that time frame, their claims are forever waived. Latches. See latches below. Unreasonable delay or negligence in pursuing a right or claim, almost always an equitable one, in a way that prejudices the party against whom relief is sought. That's right. They want to act like they have the right under equity to do anything to our estates. Just lock them out by latches. That's how we do this. Okay, so I'm not going to read the rest of this. This is for the rest of your guys' reading enjoyment, and it's in the mega file. It's also for mega file for this class, and it's also in the mega file for the VSOF status doc set. So I just wanted to have you guys understand that, take a look at it, understand what the house seal is and why it's important, right? So, section 33, cases declaring process without seal void. The long religious adherence to form and ceremony in England naturally results in the courts of that country pronouncing writs not properly sealed to be void. Numerous and most respectable American judges have approved and adopted the English rule, which is said to be the law of the federal courts. Notice that, because of the opinion of Mr. Justice Miller in 1867 in the often cited cases of Insurance Company versus Halleck. There was in question the validity of an order of court directing the sale of property, which order was by statute of Indiana required to be under seal of the court, and was declared to be process and void because of the omission of the seal. The only part of the opinion of the court delivered by the erudite judge, whose name is ever to be mentioned with thoughtful regard of his place among the ablest jurists of the world. Well, that's quite a bit of floral language for him. That concerns the question and is of interest is as follows. Quote, the authorities are uniform that all process issuing from a court, which by law authenticates such process with its seal, is void if issued without a seal. Counsel for plaintiffs in error have not cited a single case to the contrary, nor have our researchers discovered one. Our researchers, that means he got interested in it himself and went and looked it up. This is a most surprising declaration because it is most egregiously incorrect, or so this author thinks. And I put a note here. And yet, how can it be incorrect when right below in footnote 18, even the Supreme Court has said so? So I don't see this as being incorrect. I agree with what that judge said. Yet this case, maybe that's why he was so floral about praising him, because he was going to tell him that it was egregiously incorrect. Yet this case is the precedent that induces the federal courts to pronounce void all process not sealed. Its assertion is true as to criminal process only. The courts of the following states and territory, well, that's kind of interesting. Its assertion is true to criminal process only. Well, okay, even that be the case. That would still be really interesting. Anybody get charged with a federal crime? Federal grand jury? Anything from the federal courts? If it's not sealed, apparently you can just sue it out of existence. To continue, the courts of the following states and territories have approved the English rule that process not sealed is void. North Carolina, Maine, Iowa, Arkansas, Indiana. Anyway, I'm not going to read all these, which have probably changed since this creation of this treaty. And the United States Supreme Court so declares. That's the one that's important as far as I'm concerned. Now, how or when this would have ever been overturned, it's a little bit perplexing to me. I seriously doubt that it would have been, but I haven't done due diligence, so it can't hold me to it one way or the other. But at least it was declared then. All right. So this is an array of authorities that would seem to be conclusive of the question. It is proper that the reasons given for the conclusion reached and announced should be stated, and this can be best done by quotations from some of those cases. The common law requires that the seal of a court of record be affixed to all its writs. Can't get more blatantly obvious than that. The seal of a court is as indispensable to its writs as the seal of a party is indispensable to his bond. Well, there you go. That makes perfect sense to me. Quote, so long as a seal is required to be affixed to writs and executions, though we may not be able to discover its real use, yet we must not dispense with that which the law requires. Precisely. In one of the Iowa cases cited, a writ of attachment without a seal of the court had been issued and executed. A motion to quash was overruled by the lower court, which action was held by the appellate court to be erroneous. The remarks of the latter court are interesting, and some of them are here quoted. Quote, before the property of the defendant could be seized, it was indispensable that the plaintiff should obtain a writ. A paper issued by the clerk in the form of a writ is no writ unless it has impressed upon it the seal of the court from whence it issues. Right. Without this seal, it is no more for the purpose of a writ than a blank paper. Could it be amended? Not at all, for there is nothing to amend. It lacks the essential ingredients of a writ, and it is not amendable. It is the seal, other things being right, which makes it a writ, gives it force, efficacy, and life. Fully agree. The Supreme Court of Maine has said, quote, the process of each court is by law to be under its own seal. And the impression is not here a mere matter of form. A seal has been adopted by this court with appropriate devices. It gives additional solemnity to the papers to which it is affixed and renders it more difficult to forge or counterfeit them. We regard the seal as a matter of substance and the process being an original writ, not amendable. The statute requiring process to be under seal is declared in Illinois to be imperative, and that writ without a seal is void. But little consideration is given the question. The Supreme Court of North Carolina thus reasons, quote, a process by which a man's person or property is liable to be affected ought to bear on its face the highest evidence of authenticity, well, authority as well. And the law has also considered that the writs issuing from a court are most satisfactorily proved by the seal provided by public authority, which every man is presumed to know. It is also said the omission to seal process, quote, this is a substantive and not a merely technical objection. It impeaches the very act by which jurisdiction is to be acquired over the defendants and rests on the noncompliance with a statute requisite. Again, here I want to stop and make another point about this. Any time that they do not follow the Constitution, or any time they do not follow proper statute, as far as due process is concerned, which is the totality of what this treatise is about, you stop everything, you file a motion to quash it, or you file a motion to dismiss the whole fucking thing. Because they're supposed to know the law. If they don't follow it, particularly in aspect of due process, they have, whether you realize it or not, have trespassed upon one of your substantive rights. If you really want to think about it, any time that due process is violated, the substantive right that they're trespassing upon is your right to a speedy trial. Oh, I screwed up and I need 2 more months to fix that, Your Honor. What, while I sit in jail? No, thank you. Right? To continue. And the process of a court having a seal can only be evidenced by its seal, which is the appointed mode of showing its authenticity. The Texas court speaks about the solemnity of a seal, declaring unsealed process to be absolutely void. Right. In South Carolina, it is announced that should a statute prescribe a seal, it must be followed. But it is not said whether a violation of statute would render the process void or voidable. A novel reason for the necessity of sealing process is this. It gives the instrument a higher grade of character, arrests the attention in the hurry of business, allowing a pause for reflection, which is exactly what I brought up earlier tonight about when you sign and seal something and they open that up and they look at it and they see an official seal from your house, they will pause and seriously read what's actually on that piece of paper. Okay. And just my note here. So on that note, when you see a seal on a notice, when you see your seal on a VSOF status document, when you see your seal on writs, judgments, and execution from your court of record, the other party will always stop and look at your seal. So make it look great. Make it look proper and put it in the correct location on all of your documents. And with that, we've come to 9 o'clock to our hour. I will make a point to come back here at page 118 and pause it there. And so I didn't see anything in chat. So I'd like to thank all of you for coming. I'd like to thank all of you for listening. This has been the Vocational Science of Freedom Saturday Night Civics and Sovereignty class and our continued reading of a practical treatise upon the law of writs. And we will continue this on next Saturday. And until then, enjoy the rest of your weekend and stay safe and definitely stay sovereign.